Yeah, thanks, Mr. Chairman. I introduce Rebecca, who's my General Counsel, Matt Paterson, who's my Chief Policy Advisor. I wanted to come here in person because I don't think this committee has actually ever called for my input, but the matters under your scrutiny overlap completely with a lot of the work that I do. So I thought I would actually turn up on this one. My interest is obviously because offshore renewables are a good thing environmentally, but my interest is also in whether the bill is actually set up in a way that's most likely to yield the benefits. And I've got a few suggestions which I think could improve the bill. Now, you could just say, leave it there and we'll ask officials, and I hope you do. I will be looking to see what officials say in response to this. So is my analysis cogent, or do they dismiss it? But I think you should ask them about the issues that I've raised. I just need to draw attention to two issues, which if you've read the submission, you'll know are there. One is the extent to which it really does minimise barriers to the uptake of offshore permits. And if you're going to grant exclusive rights to people to build wind farms at sea and so on, then they need to be able to know that nothing's going to get in the way. And the bill is silent actually about other potential uses. Lots of things go on at sea. And if you want investment certainty, which I think is really the crucial issue here, I mean, if people are going to invest tens, hundreds of millions of dollars, then they need to, and we get the environmental benefits of that, then they need to know exactly what they are investing into. And I think that you should look at some criteria and a decision-making process to prevent new activities that are incompatible with offshore renewables from being granted approval in an area that's subject either to a feasibility or a commercial permit. Now, that is a segue into a much broader issue, which I raised at the end of the submission about marine spatial planning. And I think you really need to address this issue. And if you can't address it, and of course, that's a much bigger issue than this bill, but I think you should be recommending to the House or recommending to the government that it actually picks this up and thinks about it. Because I think we're all agreed, all parties seem to be agreed that an element of spatial planning in the big sense makes sense on land. Well, it makes sense at sea as well. But we don't really have the tools to do that. And there's a lot of things that go on at sea. And if you can, in a broad spatial sense, say, okay, these areas are green light for this or red light for this, then that makes it a lot easier for any applicant. And again, it goes to the investment certainty point. There's also a pendant issue running off that. You are granting exclusive use of space for something. That's got to be worth something. I mean, it's great to set up new systems and then the taxpayer ends up sort of funding all of this. For my part, I think the Crown's entitled to a resource rental for the exclusive use of space. I mean, we have resource rentals for minerals. Why can't we have resource rentals for space here? And there's going to be no better time to at least put your foot through the door on that one before anyone's got exclusive use rights. If you hand them out without some sort of levy or charge as a quid pro quo for the exclusive access, then if you try to introduce it later, they'll say, oh, this is terrible. This is unfair. You're introducing a charge. We went on the basis there wasn't one. Well, why not put one in at the beginning? And then you've established the principle. The other, just a short point, you may have noticed I've said something about, it's under the title, workability with environmental legislation. I think the view of my colleagues here and I is that this is much simpler, clearer legislation than you've got with Crown Minerals, and it may well be something you should look at if you're looking at the Crown Minerals legislation. But anyhow, we think that the bill could be clearer on how this Act relates to some of the other legislation, specifically the Resource Management Act and the EEZ. Just make this point, if you're giving exclusivity to somebody and that somebody, the permit holder, fails to get an environmental permit under the RMA or whatever, they shouldn't be able to sit on the permit to stop others investigating or developing in that area. If you can't get all the consents, you can't sit on your feasibility permit, which keeps others out. And similarly, I think that if a permit holder is repeatedly and significantly in breach of any environmental permits they do get, then when other providers might be more environmentally responsible, you should be able to revoke the permit. Now, I know that the bill says for any other reason. As the Environment Commissioner, I think that's a pretty important one. It wouldn't hurt you to specify. So those are the principal points. It's a good bill, and I'm broadly supportive of it. I think it could be better. You should ask your officials specifically about the points. I say your officials, the government officials who are advising on the bill, specifically whether they think these would be useful improvements, and if so, you should make them.
Okay, thanks. But I'm going to start off by asking a couple of questions. The first one of them is going to the last thing that you said, which was about so you've got your feasibility permit, you applied for consent, you didn't get it, or you're taking time to get it. Should we be specifying some sort of time frame which you should be doing that within, or at least be able to demonstrate reasonable progress towards doing that?
Well, yeah, I mean, that might make sense. Again, it's going to come down to the way that whatever timeframes the other piece of legislation, the RMA or whatever, is operating under. I mean, the default position, you correct me if I'm wrong, Rebecca, but would be if there's a time frame running under another act, then you should be able to run that time frame.
Absolutely.
But you shouldn't be able to go further.
Showing progress.
Yeah.
Okay. Look, and the other one is just in terms of resource rental. I mean, if you were doing this on land, you would certainly have a resource rental to somebody.
Yep.
For
exactly.
action. Do you have any concept of how one might value seabed, given that generally speaking, it's, value is usually about position and wanting use of it. It becomes most valuable when other people want to use it,
exactly.
which of course is possibly when you don't want to use it. So,
exactly. Yeah. Exactly. No, I mean, my chief economist is sick in bed today. Otherwise, he might have been here. But I mean, it's a big and important question, and I think it's one that the government and the committee should interest itself in. I don't have a off the back of the envelope way of doing that. I mean, economists will have all sorts of tricks of looking at option values and what they are over time. Too. Yeah, but it's because it's a synthetic thing and it's not going to be perfect, but because it's not perfect, it's not a reason for not doing it. And in fact, I'm not suggesting that you try to fashion a resource rental. I'm suggesting that you impose a levy or a charge, which is at least putting a marker in the ground that we have given you something valuable. That's exclusivity. It's worth something.
Okay, Megan.
Thank you, and thank you very much for the submission. There's a bunch of stuff going to ask for some advice on, but one of the kind of really present issues that we've got, and if we wait for the longer marine spatial planning piece of work, is the fast track bill. And the fact that we have a particular project in terms of Trans-Tasman resources that's in the Act, and it's indicated that they're going to launch. The Environment Defence Society in their submission have proposed a kind of a short-term solution around that this bill should amend the FTAA to include this bill as a specified act, which would mean that the application of the feasibility permits would become a completing application that needed to be resolved before fast track approvals could proceed to panels for decision. So it's kind of a short term in the face of what we've seen as we've already seen some investors leave New Zealand, citing this as one of the reasons. I know you've given a lot of thought to the fast track bill, but it might be worth having a look at that EDS submission if you haven't already, to have a look at that.
You're across it?
Yeah.
I think that is a legitimate option that the committee could consider in terms of solving the incompatible activity issue that the Commissioner has raised.
But as a short term rather than a long term.
Obviously, marine spatial planning is the gold standard, but well beyond scope of this.
But you wouldn't want to, and anything you could do to preclude the compromising of future marine spatial planning, I think would be a good thing.
Sure.
And I think our submission also suggests you probably need to amend those acts to prevent future applications that would be incompatible.
That is very important.
Yeah, and just really key, just one small point. I really like your point around the fact that around the kind of like the seabed banking element.
Yeah.
The bill has tried to stop that, learning from Japan and what happened there. But I think that point you make about that it could be inadvertent because you're denied a permit under a different regime.
Exactly.
So I think
Yeah.
that's a good point to look at.
Okay, but we're running a little bit ahead of time, which is good. And we don't have our next submitter, which is also helpful. And you guys, I think, are very important to hear from a little bit more. So on that basis, I'm going to go Dan Scott.
Thank you very much. And as always, a very good submission from the Parliamentary Commissioner for the Environment. Just regarding the significant influence provisions, very good points there around just streamlining that. What's your recommendation exactly, though? Do you think that we should just keep it like the Crown Minerals Act and just we don't need it, or what's your?
I don't think the Crown Minerals Act has really, and its proposed amendment, I don't think they've really understood, managed to get their heads around this yet. We don't have a particular recommendation because we're not an expert in companies law and how all that works out. So our recommendation is maybe get officials to look at this in much more depth, because the types of companies who are going to be doing this will have multiple shareholders, or there'll be investment companies that might have our KiwiSaver and the Canadian KiwiSaver. And every time something changes, like someone buys or goes a share, you don't want that company to have to report it. It just seemed when we looked at it going, this could be quite onerous.
Yeah.
But Companies Act and Share Market Act specialists and financial market specialists are much better people to provide advice on that.
Yeah, no, that's great. Thank you. We'll look at that.
Okay, Scott.
Thank you. Always expect and get a great submission. Really appreciate it. I was just looking at the acronym of this bill. It's called the OR bill, which seems somewhat ironic.
Well, it could be AWE, couldn't it? Or it could be metallic ore, so, to make your choice.
Oh, wow.
Yes.
So, but do you read this bill as an offshore renewable energy bill, or simply as an offshore wind bill? And should it be expanded to include more capacity for other renewables offshore, or should we just be explicit that this is simply for wind?
Well, I haven't thought about that, to be honest, but I'm aware there are more things than wind turbines in the sea being experimented with. I'd have thought that writing very, very specific legislation for a technology would not be your first option from a legal point of view, but I haven't explored the difficulties of trying to do that.
Yeah, I didn't necessarily do the mental exercises on what it would mean for different types, but I certainly didn't see this bill being restricted to wind energy.
No.
And in part, one of the things that I tried to think about is what sort of permits, environmental permits would be needed in this. And even if you're just dealing with wind energy, there's so many different consents that you're going to need. And similarly, if you're looking at tidal energy or anything
Or
else.
wave arrays. There's a lot of stuff.
And the bill is flexible enough because it's not prescriptive about the types of permits that you need to get. It doesn't try and second guess what the RMA or the EZX are going to do. It's actually quite sensibly left it to those acts to do that. So looking at it, I saw that it was sufficiently flexible regardless of the energy technologies that we're going for.
Okay.
Any other questions?
So
No,
we'll-
okay, well, thank you, really appreciate that. You've again
Thank
given
you.
us.
Well, we're very happy to
thought.
come if you want a crisp insight on any of the other stuff. You don't have to wait for me to make a submission. I'm there to help all select committees.
We will bear that in mind,
And
So-
certainly.
You're very welcome.
Mr. Chair,
Megan,
through
sorry,
you,
you
just if
one
there
more
is
question.
any other work that you have done around resource rentals and levies, if your economist who is out of his sick bed has turned his mind to it, it would be useful for the
Or
committee to see it.
would you be interested just in a one-page note on the challenges of developing resource rentals in the marine space? I could give you something if you'd like.
Yeah, no, all right, we'd appreciate that, yes.
All right,
you.
we'll do that.
If you can do that in a timeframe, what's the timeframe we've got
Thank
to consider at least the departmental report will be
Next sitting block.
next sitting block?
Sorry, when is it?
Our departmental report will be next sitting block, so how long do you think it would take to
So
do that? Just
before Easter or after
Before Easter.
Before Easter, yes. If there's a chance of doing it, then the sooner we get it, the more.
The quicker it is, the
we can use
more
it.
high level and brief it'll be,
Yeah,
but
okay.
yeah.
But
okay.
whatever you can do. That'd be
Okay,
appreciated.
very
Thank you.
Thanks very much.
Appreciate it.
Thank
Thank
you.
you.